Paul, the member for Newtown.
Thank you, Speaker. On behalf of the Greens, I rise to speak on the Crimes Legislation Amendment Coercive Control Bill 2022. And while I note serious concerns with the government's bill expressed by the sector, which I will go into in the course of this contribution, I can confirm that the Greens will not be opposing the bill in the Legislative Assembly, as the Greens, through our colleague in the other place, Abigail Boyd, have secured an inquiry into this legislation in the hope that some of the serious concerns raised by those in the sector and those with expertise and lived experience can be listened to, and they can be addressed in the bill, and we see it back here in a different form before we end the parliamentary term. The Greens support criminalising coercive control, but crucially we do so in close consultation with and with support of the domestic violence sector and those with lived experience. The Greens are only in a position to support this bill on the basis of recognising that significant amendments would be needed and required in the other place to be able to achieve those aims. Criminalising coercive control is a hugely important reform, but it has to be done right, or it will create more harm than good. And we have heard that consistently in all of the consultations that has taken place. I want to start by acknowledging, as the Minister for Emergency Services did when she spoke, that some of what we are talking about here today is sensitive, and when talking about issues of domestic and family violence, we need to recognise that the reach into our community is so significant that there would be nobody in this place who does not have personal experience of or a connection with someone who has experienced domestic and family violence or personal violence. Coercive control is an insidious form of domestic and family violence that often leads to physical abuse. Many victims of domestic abuse live in constant state of fear, in relationships marked by dangerous patterns of controlling behaviour. Perpetrators of coercive control seek to control their victims with actual or threatened harm. Harm doesn't always or necessarily mean physical violence. It manifests itself in a variety of ways. It could be the grabbing of someone's phone. It could be the providing them with more alcohol than they want to consume at a certain time. And it could be a whole lot of range of controlling people's finances, people's connection to family, people's connection to community, and people's autonomy to be able to make choices for themselves. The seriousness of coercive control and the nuanced ways it manifests necessitates a considered response, which is exactly why this Parliament took the issue to an inquiry, and that inquiry recommended a variety of reforms spanning all corners of the justice system and domestic violence sector, and a staged process for its implementation. We must criminalise coercive control, but doing it the wrong way risks creating more harm than taking no action at all. The proposed bill would create an offence in the Crimes Act 1900 to criminalise coercive control in current and former intimate partner settings with a maximum sentence of 7 years imprisonment. Key concerns that the New South Wales Women's Alliance, backed in by more than 220 domestic and family violence advocates, have raised about the proposed bill are as follows. They are concerned that requiring proof of a specific intent to coerce or control places would place a significant burden on the prosecutor. They are concerned that the bill is limited to intimate partner violence, excluding many forms of abuse suffered by victims in the community. They are concerned that there is no singular concise definition of coercive control. And they are concerned that there is no contextual definition of domestic and family abuse, which will cause confusion when the legislation is put into practice. It is incredibly disappointing that instead of listening to these concerns and to the committee and to the domestic violence sector and to those with expertise as a result of their lived experience, that the government is choosing to rush this through now while these concerns still remain on the table. I acknowledge and recognise and acknowledge the Attorney-General is in the chamber for this debate, that in the second reading speech, the Attorney-General noted that criminalising coercive control must be approached with great care and caution, and I couldn't agree more. Which is why I ask how the Attorney-General feels that claiming to be proceeding now when there is so much concern from the sector, from domestic and family violence advocates and experts who are concerned that they do not support taking this action right now. Members will know that the women's safety and domestic violence sector is unanimous in their opposition to this bill as it is currently drafted, because they have taken extraordinary steps of writing to all MPs in New South Wales Parliament to try and slow its passage down. The first draft of this bill was only made available to the sector in late July, and the vast majority of feedback provided during the consultation has since been not taken on board by the government. I note that the Attorney-General went through in detail the vast length of consultation that has been undertaken, but consultation requires change. There is no point in engaging with consultation unless you are changing and shifting what has occurred in response to the experts and those with lived experience and in the sector are providing you when they provide that advice. It is not okay to cherry pick the bits that we want to take while ignoring the overwhelming other voices of concern. Which is why I want to take on the time now to put on the record the concerns that a number of women's safety and domestic violence sector advocates have raised about this bill, that it has potential to harm the very people that it was designed to protect. Chief Executive Officer of Warringah Baya Aboriginal Legal Centre, Christine Robinson, noted that the bill's narrow definition of relationships doesn't consider some communities where more people can be involved in the act of violence. She states, "The bill does not allow for the practices that may happen in Aboriginal communities, and the New South Wales Government must take into account Indigenous experiences." Redfern Legal Centre's Financial Abuse Service has repeated concerns over the rushed introduction of this legislation and the lack of proper consultation, meaningful consultation with the sector. Gayatri Naya, who also coordinates the Economic Abuse Reference Group in New South Wales, says that economic and financial abuse needs to be recognised in New South Wales, but we are disappointed that a new criminal offence has been introduced without proper and robust consultation. Women's Legal Service New South Wales also does not support the bill in its current form. We need to start with a contextual definition of domestic family abuse, violent, threatening or other behaviour that coerces, controls or causes fear. Without a contextual definition, the focus will remain on incidents in isolation, which often results in the misidentification of the person most in need of protection. Further, with such high mental elements of intent to coerce or control, there will likely be few successful prosecutions. We fear this will have the effect of providing victim survivors with false hope of protection and emboldening perpetrators to continue and even worsen their abuse, as they will likely be able to act with impunity. The Economic Abuse Reference Group, an informal group of community organisations that collectively works to influence government and industry responses to reduce the financial impact of family violence, note, the introduction of a new coercive control offence will require significant and extensive cultural and systems reform. A failure to allow the necessary time and provide appropriate resources for such cultural and systems reform will lead to an underprepared and under-resourced police force, court system and legal profession struggling to implement important reforms. The consequence may be exposing women, children and other victims of survivors to even greater risks. And domestic and family violence advocate Rosie Batty warns, if criminalisation is not given enough time for consultation with victim survivors and experts in the field, the complex legislation has the potential to re-traumatise the people it was designed to protect. The New South Wales Women's Alliance has repeatedly called for longer and more considered consultation and development to ensure that we are in the right place to introduce this legislation. Domestic Violence New South Wales, who are the peak body for the Specialist Domestic and Family Violence Services in New South Wales, Acting Chief Executive Officer Renata Field has said, "We are concerned that important issues raised by experts in the field have not been sufficiently heeded, and therefore a second round of open consultation is essential to support the best and safest outcome for victim survivors." Renata, the CEO of DV New South Wales, continues, "If the bill were to pass in its current form, we are concerned at best it would be underutilised and not really help people is set up to help. At worst, it would create issues of misidentification and not provide support to those who really deserve it." Speaker, if I could ask for an extension of time.
The question is the member's time be extended. All of that opinion say aye. To the contrary, no. Member's time is extended for 5 minutes.
The concern about misidentification is real. A recent ABC article by Hayley Gleason in March 2022 paints a damning picture. Lee, who is not her real name, lives in Melbourne with her boyfriend in the suburbs. Reaching breaking point one day, she finally calls the police. For 2 years, she's been struggling to cope with his physical violence and financial abuse, his threats to withdraw his sponsorship of her visa and have her deported if she leaves him. He often cuts her allowance to punish her, but also won't let her work casual shifts in the beauty industry, insisting she stays home to look after their child instead. When the officers arrive, she's beside herself with frustration and relief. She's wailing and grabbing her thighs, yelling in her language. The police are flummoxed. They've got no idea what she's saying, but Lee's boyfriend is calm and well-spoken. She's crazy, he tells them. She's clearly got mental problems. The officers accept his account that she's the violent one, and apparently without even trying to talk to her on the spot, they arrest her. This is not just an issue happening in Victoria. I personally know in the last days, last weeks, last months, of numbers of incidents of women of colour, of First Nations women who have been misidentified in domestic violence situations. This is a real situation. And if you are a First Nations woman and you are misidentified by the New South Wales Police, the risks of you facing a death sentence because of the fact that we have never properly implemented the recommendations around deaths in custody are real. If you are a woman of colour, if you're a migrant woman and English is your second or your third or your fourth or your sixth language, the issues of misidentification for the rest of your life are real. As someone that has suffered racist and sexist abuse at the hands of the New South Wales Police, it is incumbent on us in this place to recognise that it will not be the wealthy white women that will suffer if we misdraft this legislation. It will be the First Nations women, it will be the migrant women, it will be the women of colour who will be suffering as a result of the fact that we don't get this right and we risk that this legislation increases the number of cases of misidentification. Instead of listening to these serious concerns set out by the sector, the government is choosing to push this bill through, and despite continued claims by the New South Wales government that is listening to the consultation means you change and you act accordingly. Sadly, this is not new. We know that the government has not been listening to the absolutely desperate pleas of the domestic and family violence sector to address gender-based family and domestic violence for over a decade. We need significant boosts to funding in this area, and rushing through this coercive control legislation might change the Crimes Act, but it will not address the scourge of domestic and family abuse in our communities. I wish to acknowledge and note the work of my Greens colleague in the Upper House, Abigail Boyd, who holds the Domestic Violence and Attorney General portfolios for the Greens and who introduced a coercive control bill in 2020. She drafted this bill in consultation with academics, victim survivor experts and frontline domestic violence workers over an 18-month period with many, many revisions. I also wanted to acknowledge the tireless work of the advocates in the domestic and family violence space. It is absolutely challenging to navigate this space when many of your frontline services rely on the support of the government while you are trying to push for policy and legislative reform, and I recognise the efforts that you go to be able to navigate that space and ensure that people in our community are safe. The Greens are committed to getting this reform right, and we won't be rushed by the government, we won't be rushed by election cycles, we won't be rushed by the limits of time put us on in this chamber for debate to move to ensure that we get to the right point. We express our concern that it appears that the opposition has not heeded the concerns of the sector and plan to support the government in moving this bill forward in its current state. And I hope that in the Upper House they will work collaboratively with us to try and address some of the serious concerns that are there. We will do, as the Greens do in the Upper House, attempt to salvage this situation and ensure that the law is not used as a weapon against those it is intended to protect.